So the contract, which can be accessed on our website www.lawyers.easyfine.co.za, provides for additional clauses which may be relevant for the type of agreement that the supplier wishes to conclude with an agent. This includes granting the agent the opportunity to purchase the product on his or her own behalf. There will be direct contact between the supplier and the agent as the customer, which results in a speedy and secure transaction. The supplier will retain control of the terms of the sale of the product unless the parties have agreed otherwise. The law of agency in South Africa is predominantly regulated by common law and the Consumer Protection Act, as I have stated. There are further requirements imposed by legislation in South Africa which relate to specific transactions and in particular those concluded by agents. Common law still remains the primary regulator, however, of the law of agency in South Africa. So the common law recognizes two types of relationships between the agent and the principal, namely a relationship of representation and a relationship of mandate. In a relationship of representation, the agent is entitled to perform juristic acts on behalf of the principal and as such acts as the representative of the principal. In order to do this, however, the agent requires authority to act, which may arise from a unilateral grant of authority from the principal and express tacit or implied otherwise, or by operation of law. The extent to which the agents may incur legal obligations on behalf of the principal depends on the extent of authority granted. A relationship of mandate involves a bilateral contract in which one person undertakes to perform some task on behalf of another. The mandatory may be remunerated, and the obligation to remunerate depends on the contract of mandate between the mandator and the mandatory. As a general proposition, the mandatory is not the mandator's representative and therefore does not have the authority to incur legal obligations on behalf of the mandator. The role of mandatory is thus limited to bringing an opportunity for the principal to enter into or terminate a contract or a contractual obligation, but the mandatory does not do so on the principal's behalf. The modern commercial transactions are predominantly concluded through representation agency relationships. As such, the law detailed refers to the law governing such relationships unless the context indicates otherwise, which I will be discussing in more detail. So an agency relationship must not contemplate conduct by the agent that is against the law, immoral, or contrary to public policy. To the extent that an agreement contemplates such conduct, it will be void. The common law also distinguishes between general and special agents. A general agent is an agent who is authorized to act for a principal in all transactions for a particular nature or in all matters concerning a particular business, or in all transactions that the principal could not perform personally. But on the other hand, a special agent is an agent who is engaged by a principal for a particular transaction or a specific limited purpose. Once this purpose has been achieved, the agent's authority will automatically terminate. But now, what does the Consumer Protection Act say? Let's see. The definition of a franchise agent under the Consumer Protection Act is broad enough in scope and includes all the types of transactions and contractual terms, which sometimes include agency and distribution agreements. Thus, an agency agreement may, if certain restrictive provisions are imposed on an agent, constitute a franchise agreement, as contemplated by the Consumer Protection Act. As such, provisions which also allow the principal or supplier to dictate and impose inter alia, amongst others, business conditions and reporting obligations on an agent or distributor, could find themselves in a deemed franchise relationship and in turn subtract additional obligations to their agents or suppliers in turn. That's it of the Consumer Protection Act. But what are the formal requirements of such an agreement? So, certain additional requirements are required for specific transactions under the applicable governing legislation of South Africa. In terms, for example, in terms of the Alienation of Land Act of 1981, in order to alienate land via an agent, the agent must have the authority in writing firstly. Furthermore, the actual alienation of land must be contained in a deed of alienation signed by the parties who agree thereto, or the agents with written authority. If either of these requirements are not met, the purported alienation is then void, which means it doesn't exist or it is invalid. So, also the General Law Amendment Act of 1956, which governs suretyship agreements, holds that no suretyship agreements will be valid unless it is concluded in writing. However, the authority of the agent to conclude such an agreement does not need to be in writing. If an agreement does not fall within the aforementioned categories, the principal may confer authority to the agent either orally or in writing, and the agents may conclude any agreements within the authority conferred either orally or in writing. However, it is advised for any transaction that both the conferring of the authority and the agreements be reduced to writing and in a formal agreement, of course. This allows for the principal to clearly define the extent of the agent's powers as well as the terms of the appointment in a manner which substantially reduces the risk of a potential dispute. So let's discuss different types of agreements, like your individual or corporate entity. An agent may either be an individual or legal entity. In light of this broad definition of an employee under the South African Labour Relations Act, it is important that the formal agreements which gives rise to the agency relationship plainly illustrates that the relationship between the parties is one of the principal or agents and not the employer or employee. Then you have exclusive or non-exclusive clauses. There are no restrictions on the ability of the principal to appoint an agent on an exclusive or non-exclusive basis. If this issue is not dealt with in the agency agreements, the agents will be deemed non-exclusive. Given that the essence of an agency agreement is the conferral of the principal's peculiar powers onto an agent, the principal is then entitled to determine the extent and exclusivity of the powers so concerned or conferred. Then, what are the duties of an agent? The agent has a number of obligations towards the principal when performing under the agreements. The agents must ensure that they personally carry out the terms of their agreements with the principal, and the agent is not entitled to delegate the task to another without the principal's consent. Any permitted delegation will not give rise to privity of the contracts between the principal and the sub-agents. Then how do you confer authority in these cases? So authority can be conferred from the principal to the agent in three ways: when it's expressly granted, tacitly granted, or implied by the law. Authority can be expressly granted orally or in writing, except where legislation specifically says that the authority must be granted in writing. Authority may also be tacitly granted if a grant of authority can be inferred from the principal's words, conduct, and the surrounding circumstances. But then how do you terminate such a contract also? There are formal requirements to terminate such a contract, which is the authority of an agent can be terminated, of course, by way of the source of the authority ceases to exist, the performance was complete, or just over the fluctuation of time. If the principal dies, goes insane, mentally incapacitated, or becomes insolvent, or if the agent dies or becomes mentally incapacitated, or the special relationship granting the authority ends. If authority derives from a contract via ordinary rules of contract governing termination and through the revocation and renunciation, the relationship of the principal and agents also terminates when both parties have fulfilled their obligations entirely or substantially. The common law also places great emphasis on privity of contract, affording the parties the right to contract on their own terms. Within the confines of public policy, to end a valid and binding contract is created when agreement is reached orally or in writing on the basic terms of the agreement at hand. The common law does not provide for distribution agreements specifically. Instead, the general principles of contracts apply to distribution agreements. The Consumer Protection Act seeks to provide protection to consumers from abuse by suppliers. As a general point of departure, the Consumer Protection Act imposes certain formalities in respect of all transactions that qualify as being subject to the Consumer Protection Act. This includes that all agreements must be in writing and must be written in plain and understandable language. In the context of distribution agreements, plain and understandable language would be that which is understood by people within the industry of average literacy, skills, and minimal experience. The Consumer Protection Act further prohibits unfair, unjust, and unreasonable terms and prevents the supplier from requiring a consumer or other person to whom goods or services are supplied at the direction of the consumer to waive any rights, assume any obligation, or waive any liability of the supplier on terms that are unfair, unreasonable, or unjust. Furthermore, such terms are not imposed as a condition of entering into a contract. As such, any terms in an agreement, including those terms relating to price and definition of the main subjects, which are in breach of these terms, would be subject to legal challenge by the relevant consumer. In addition, there are four types of clauses which must be brought to the attention of the consumer in conspicuous manner. These include exemption clauses, assumption of risk clauses, indemnity clauses, and acknowledgement of fact clauses. So that's it for today in this video. If you guys are interested in any more, please like and subscribe to our YouTube channel. Click the subscribe button, click on the post notification button for more videos, and there are many more videos like